position. If we can be recalled, in 2013, we had the current president and the former president, His Excellency Uhuru, facing trial at the ICC. And a 5-judge bench was presented with that scenario. And they ruled that, A, the presumption of innocence against any accused person operates to bar any accusation as though and to pass the verdict of guilt at that stage. B, the second issue is that the Constitution does say that until you exhaust the appeal mechanisms, you still have your presumption of innocence and the right to vie, because you have not exhausted the appeal mechanism. Even though stage 1, you have found yourself accosted by this verdict of you're guilty. Then you appeal, and on appeal probably that is overturned. And then again there is another superior court. I mean, it can go to the Court of Appeal, or it can go to the Supreme Court, where now the verdict could be hanging while the election process is ongoing. Let's remember that the final verdict may decree or declare that in fact you are innocent. And therefore, whatever position that you took up at the point that the trial was ongoing is affirmed, and therefore you can't lose your seat. But again, if the final verdict is that, look, you know, the very first incident of your having been held guilty, that stands. So you lose your position. You
so even if you are president and then the court declares that you're actually rightfully impeached, then you lose that position?
Then you lose that position. Wow. So let's accept that is a constitutional underpinning that we have in terms of that. And that was resolved, settled in 2013, which is why when President Uhuru Kenyatta was elected and the current president as his deputy, that issue did not arise during the presidential election at all. It was resolved at that point. And even on appeal, it was resolved that that is a legal position. So I haven't seen a shift in terms of the script of our Constitution. Nothing has changed in terms of our constitutional provision. And in terms of precedent, that pronouncement also has not changed. But now coming to His Excellency, the former DP, Gachagua, you can speak of him not exercising his political right. Let's remember, Article 38 of the Constitution confers upon you, anybody, everyone in the Republic, to exercise that political right without any restriction that is crystallized in law or in a court judgment. So that brings us again to the cyclical argument that, look, he hasn't had a final verdict. And like we have been told, the Senate did render its verdict. So the case is pending right now, adjudication before the High Court. It's supposed to come up on the 23rd of October. And there are issues that have arisen. So it may take a longer period than the 2027 election period in terms of conclusion, and therefore he may have that opportunity. Finally, why is it raising a furore? Why is it, you know, an issue to some people? Because some people had imagined, and especially they who are in government, that by impeaching him, you have buried him. You have buried the constituency that, you know, he was supporting, and therefore you have to realign. In my humble view, it would be wrong to stifle and to try and constrict, or as it were, totally obliterate anyone's right to exercise their political rights. And therefore, being his right, we should all accept that he has as much right to say what he wants to say within the political space that is afforded him by the Constitution and the applicable law.
All right. Now let's look at...
Well, before you go to Wakili, good Wakili here is telling us the appeal may go beyond 2027. And he's telling us as long as it is alive,